For the second time within a short span, Bola Tinubu is making another attempt to impede Atiku in a U.S. federal court in Chicago from obtaining his academic records from Chicago State University. Atiku Abubakar, one of Tinubu's opponents in the recently concluded Nigerian presidential election, has initiated this legal action. The reason behind Atiku's motion is the disparity between the certificate that Tinubu presented to the Nigerian Electoral Commission and the one issued by Chicago State University during his time there. Uncovering this discrepancy prompted Atiku to subpoena Chicago State University for the certificate that was conferred upon Tinubu upon his graduation, which was then submitted as evidence in court. Atiku is currently challenging the election results and Bola Tinubu's declaration as president. As per Nigeria's constitution, anyone who submits a forged certificate to the Independent Electoral Commission while vying for an elective role is subject to disqualification upon verification. Thus, Atiku is urging the court to disqualify Tinubu based on this discrepancy between the certificates. Tinubu, in his bid to prevent Atiku from accessing his Chicago State University records, contended that this action infringed upon his privacy rights, citing a 1974 privacy law for American students. Atiku's legal team found it perplexing that a public office holder would obstruct someone, let alone a fellow contender, from accessing educational records, especially in a contested election. Regarding Chicago State University's standpoint, they do not oppose Atiku's application and do not view it as their obligation to hinder access to Tinubu's educational records. The question arises, would Tinubu's privacy genuinely be violated by the disclosure of his Chicago State University records? In actuality, no. First and foremost, let's consider the perspective within Nigeria. When an individual seeks an elective position, they are required to complete forms provided by the Independent Electoral Commission. These forms encompass various details about the individual, including personal information, educational history, age, and more. Consequently, this information becomes public once submitted to the Independent National Electoral Commission, INEC, a governmental body responsible for conducting elections in Nigeria. A candidate participating in an election can access this information through a court order or subpoena, precisely what Atiku Abubakar did in this scenario. By subpoenaing INEC to furnish these documents, Atiku obtained the information and subsequently compared it with the records he acquired from Chicago State University. Here you can observe that the document on the left is the one Tinubu submitted to INEC, marked with the official INEC stamp. In contrast, the document on the right was obtained via subpoena from Chicago State University. A notable array of differences becomes evident. The number of signatures varies, with 3 on the produced document versus 2 from the university. The fonts and headings also differ substantially. This dissimilarity prompted Atiku Abubakar to seek additional information from the U.S. university. It appears perplexing that an individual who previously attended Chicago State University couldn't simply approach the institution to request a replacement certificate due to loss or damage, a process as straightforward as presenting a valid reason, such as fire damage. Ordinarily, the university would issue a new certificate upon verification, which could then be officially submitted to INEC. Could it be that the enrolled individual at the university wasn't actually Bola Tinubu? The possibility arises that he might not have undergone the necessary administrative procedures, hindering his ability to gather the requisite information to obtain a new certificate if ever needed. This scenario seems plausible. When requesting a new certificate or a statement of results from a university, applicants typically complete a form provided by the institution. The details supplied on this form serve as proof of past enrollment. Now let's delve into the actual narrative, the identity of the true Bola Tinubu. Every individual has a narrative, a history that surfaces when they step into the arena of an electoral contest. This phenomenon isn't unique to Nigeria. It occurs worldwide, spanning the US, the UK, and other nations where political elections are fiercely contested. As the Fourth Republic commenced in 1999, a surge of political aspirants emerged, seizing the opportunity after years of military rule. This fervor led to a surge of candidates vying for governorships, local government chairs, presidential positions, and senatorial seats. In the realm of politics, competition prompts contenders to delve into each other's pasts, seeking any form of ammunition, be it missteps, inaccuracies, or forgeries, that could serve to disqualify opponents and secure an advantage. This scrutiny bore fruit when discrepancies surfaced in the governorship form Tinubus submitted to INEC. An amusing account relates to the secondary school he claimed to have attended in Ibadan. The school, upon learning of Tinubus' assertion, initiated plans for an alumni gathering. Yet even during the preparatory stages, several alumni voiced their unfamiliarity with Tinubu. A level of awkwardness pervaded the situation, leading to the event's cancellation. Subsequently, Tinubu attributed the misrepresentation to an associate who completed the form on his behalf, citing an inadvertent error. Consequently, he omitted the secondary school information entirely from his CV during the recent presidential election. Furthermore, Tinubus' gubernatorial form was marred by inaccuracies and outright falsehoods. These discoveries were pivotal during the period of heightened competition in the nascent Fourth Republic, revealing a facet of the political landscape where candidates' pasts are scrutinized to secure an upper hand. Now turning back to the narrative. Who truly is Tinubu? During the period when the Ibadan school controversy erupted, a rumor circulated in Lagos suggesting that Tinubu was adopted, with his stepfather having a daughter studying in the United States. Interestingly, this daughter bore the name Bola Tinubu. Unexpectedly, she passed away, providing Tinubu with an opportunity. He seized her passport and traveled to the United States. Back in the 1970s, Nigerians enjoyed visa-free entry to the US, the UK, and numerous Western countries. A mere plane ride sufficed, granting a 90-day stay unless an extension was sought. Although it might seem unnecessary due to the visa-free policy, considering that she was a US resident, it's understandable why he utilized her passport and documents to travel. This action facilitated the inheritance of her possessions, including those tied to Chicago State University, where she had been enrolled. This story became widely known, not limited to Lagos, but spanning across Nigeria. Dino's tweet further accentuated the narrative. This explains why Tinubu is blocking Atiku's access to these records. They could unveil the genuine identity of Bola Tinubu. The revelation that the person linked to the Chicago State University records was female initially emerged through the investigative work of Nigerian journalist David Hundeyin. This revelation emerged last year prior to the presidential election. At that point, Atiku didn't take this matter seriously, as it gained traction as an online sensation. To emphasize the gravity of the issue, a video was even produced. Hundeyin, an investigative journalist, meticulously delved into the backgrounds of all presidential candidates. One candidate's history stood out, revealing a history riddled with forgeries and document-related scandals. The disclosure that the university's attendee was female shed light on the situation, transforming it from rumor to fact. This is why Atiku is now pursuing these documents, aiming to present them in court as evidence that the individual in question is an impersonator. Once these documents are brought forth, a cascade of revelations will ensue, likely culminating in disqualification. This outcome is practically certain, as it aligns with the straightforward language of the Constitution. The reason behind the lack of records on Bola Tinubu beyond 1970 becomes clear. His absence from secondary school, primary school, or any information pertaining to him beyond 1970 within Nigeria can be attributed to his adoption of this new identity after he journeyed to the United States. An instance surfaces where he purportedly claimed employment at Deloitte, attempting to rationalize his substantial earnings while serving as an accountant. However, Deloitte categorically denied any knowledge of him. They conducted thorough searches through their data and records, failing to locate any trace of a former staff member named Bola Tinubu. This case essentially boils down to a straightforward matter. Atiku should have regarded Hundein's revelation with the utmost seriousness when it surfaced last year. He should have promptly gathered the necessary information, had it notarized, and made it readily available. Elections frequently conclude within courtrooms, as disputes often arise. INEC personnel often appear to sway towards the highest bidder, making the court's decision the ultimate determinant. During the presidential election petition case, Tinubu's legal team had no effective counter-argument against the forged certificate presented in court. Their sole contention was the lack of oral testimony from Chicago State University confirming the certificate's origin, a weak argument considering the genuine certificate was provided as evidence. With a plethora of substantial evidence before the court, Tinubu's disqualification appears inevitable, a reality acknowledged by the court itself. When a party obstructs evidence, the court presumes that the suppressed information would be detrimental to that party. Tinubu's active suppression of evidence suggests his recognition of its potential harm to his case. This scenario mirrors INEC's refusal to comply with subpoenas and provide the documents demanded by the Labour Party. This obstinacy signifies a desire to shield the falsely declared candidate by withholding evidence. Such actions can be seen as a tacit admission of guilt. Innocence, on the other hand, would prompt the voluntary submission of all documents, even those not explicitly requested, to substantiate one's claims. As the saying goes, a clear conscience fears no accusation. In this context, an innocent party would openly present all evidence, confidently proclaiming their innocence. Picture this: INEC boldly asserting that the election was immaculate, no rigging, flawless execution. Now, they're met with a simple request: present the evidence, let's scrutinize the numbers, the figures. But what unfolds is nothing short of incredulous. INEC hesitates, evades, and astonishingly claims, "We lack the results." No justification, just dodged subpoenas in an utterly baffling situation. This entire scenario is nothing short of a comedy. Even the lone witness they summoned against the Labour Party ended up contributing to the hilarity. His statement, nestled within paragraph 22 of his witness account, reads, "I recognize that the genuine and legally mandated data repository for referencing results pertinent to the resolution of this petition or the examination of the election is the iRevi portal." Here, his testimony contradicts the very stance they uphold in the courtroom. In essence, his words align with what the Labour Party, the petitioners, presented in their case. Adding to the irony, during their final address, INEC implores the court to treat the IREV copies they provided as certified true copies, asserting that these copies mirror the hard copies they purportedly used for collation. INEC, in a peculiar twist, echoes the petitioner's argument, virtually suggesting that the IREV copies should be employed for collating results. This surreal situation couldn't be more fitting. Thus, we eagerly await the impending Judgment Day, an event that should transpire within a fortnight. All eyes are riveted on the judiciary as we eagerly anticipate the resolution of this extraordinary affair. If you are watching our video for the first time, I suggest you subscribe to our channel for more interesting and captivating information. Turn on the bell notification to get alert on all our recent posts so you won't miss out any. Share your thought in the comment section and share these videos with family, friends, and concerned Nigerians. Thanks for watching.